Hi, I'm Ken Lammers, and I want to welcome you to today's LexCast. Today we're going to discuss three decisions from the Supreme Court of Virginia, one of which is a decision by the Supreme Court not to consider an argument. The second of which is, in the first part, a major part, a decision by the Supreme Court over whether or not one can be found guilty of attempting to have sex with a minor when no minor is involved. And the second part is about the Supreme Court refusing to consider an argument. And the third is a habeas, and this habeas concerns whether or not it's ineffective assistance of counsel when a defense counsel does not object to the fact that his indigent client is going to be tried in front of a jury in his prison jumpsuit. It's a habeas because, not having made the objection when this point was raised in the Courts Appellate Virginian on the direct appeal, it was not considered by the courts because they refused to consider it because it was not objected to during trial. And so, there's a basic theme today as to what's going on in Supreme Court's arguments. These are actually decisions from 2 weeks ago from the Supreme Court. This last week there was no decision from the Supreme Court, and there was no decisions from the Court of Appeals, at least no opinions that were published. Generally don't discuss non-published opinions because if you concern yourself too much with the non-published opinions, you will eventually go insane. So, ladies and gentlemen, here we go. First, before we go through and discuss the actual opinions, I want to cover a point of law in Virginia. This is Rule 525 of the Supreme Court of Virginia, or Rule 5A18, which is the same rule for the Court of Appeals of Virginia. Now, this rule basically requires that, it basically says that the appellate courts in Virginia will ignore any argument or any error which is not raised by objection or argument by the defense or either side in the trial court. There are exceptions. There is the exception for good cause shown. I've never seen that exception actually applied in any case, in any appeal, or at least never accepted by the courts in any of these cases. I'm not omniscient. I may have missed some. There may be dozens of them out there, but I can't remember any single one. The other exception is the ends of justice exception. This one is applied. I have seen it at one time that I can think of off the top of my head. It's applied about once every third or fourth blue moon, narrowly, very strictly applied, and obviously is a disfavored doctrine. However, it is possible to have this one applied. Basically, ladies and gentlemen, let me say, these are the arguments. The point behind this sort of rule is so that when you end up in a situation which every defense attorney's ended up in, where you've tried the case, there weren't really any significant errors, and your client turns to you and says, appeal the case. And you go, appeal what? And your client says, appeal the case. You have to appeal something. So you scour the transcripts looking for anything. And you find some obscure rule or some obscure case that says that in the indictment there has to be a comma between the third and fourth sentence of the indictment. And then you raise this argument in the Court of Appeals for the first time, despite the fact that it really doesn't accomplish anything. It's not really changing anything. It's meant to weed out those sorts of arguments. However, the way in which it is more usually applied is something along the lines of this. The defense counsel does not save the argument, preserve the argument in exactly the proper format. An example here would be trying to strike someone for reason from a jury. So defense counsel questions a juror and decides that he's going to move to strike this juror for reason. And the judge rehabilitates her. And we've all seen this. Anyone who's been a defense attorney has had jurors rehabilitated in this fashion. And it goes something like this. And this is the judge. Mrs. McGillicuddy, I know that you said that your grandfather was a police officer and had arrested the defendant's grandfather 6 times, and that your father was a police officer and had arrested the defendant's father 7 times, and that your brothers are both police officers, and while they haven't arrested the defendant, they've arrested members of his family, and that your husband's a police officer, but luckily enough, he's only arrested the defendant's sister, and that your 3 sons are actually in the police academy, but they haven't had any opportunities to arrest anyone yet, and that you looked at the defendant, and the fact that he has a unibrow makes you think that he's more likely to be guilty. Now, I know you've said all this, but if I explain the law to you, and I tell you that he's presumed innocent until the end of the trial, and that you must consider all the facts and the law as I lay them out to you, do you think that you could keep a fair mind and try this case in a fair and honest manner? Why, yes, Your Honor, I think I could do that. Mr. Lammers, I just don't see any reason to strike this lady. Motion denied. Okay, so then you object, right? And you preserved your objection. Perfect. Well, no. What comes up next is, at the end of jury selection, there's 12 people sitting in that box, or maybe 13 or 14 if you've got a cautious judge. And just about to start the trial, and you don't object to the seating of the jury in its entirety. Because, well, you've already made your objection, and you've already given the grounds for your objection. Nope. You just lost it by not doing it in exactly the proper format, objecting both at the time of the motion to strike, and at the time, or motion to remove for reason, and at the time of the seating of the jury, you've waived all the errors that you have previously preserved in the jury. Things like that. There's also things such as, well, for instance, in Virginia, you have to file ahead of time, at least 7 days ahead of time, on certain constitutional rights if you want to preserve your right to argue them. For instance, your 4th, 5th Amendments, speedy trial, and speedy trial is something that was just added this last July. You have to file the motion 7 days ahead of time in order to be able to argue those to the court. And now here's the difficulty. Virginia is a trial by ambush state, as we all know. So you have very limited discovery. If you don't know something, or if you don't realize something until 3 days before trial, and you try to raise the objection at that point, well, then it's at the discretion of the judge whether or not to give you extra time to brief and argue this. If the judge says no, you've lost that. You haven't properly preserved the argument for under 5A18 or 525, and the courts of appeal will not consider the argument. So, if your client was beaten for 12 hours with a wet noodle until he confessed, and you don't raise the objection within the proper time limit, well then, it's gone. Now, I'm not saying you shouldn't raise it on appeal, but the odds of actually being able to do anything with it, hey, that's gone. You're probably not going to win there. Now, let me say, I don't like this rule, but I've been hypocritical about it. I've used this very same rule once in a case to keep the prosecutor from being able to appeal something. I can't remember exactly what it was at this moment, but whatever it was, the prosecutor lost the argument and didn't object. And so when he tried to appeal it, I raised 5A18, and the Court of Appeals dismissed it because he hadn't objected in the trial court. These rules are kind of interesting because right now our Court of Appeals, our courts appellate, are kind of in a flux situation right now. If you're not from Virginia or the D.C. area, you may not realize this. But over the last couple of years, the Washington Post has just been beating the Virginia judicial system over the head with the fact that all sorts of people's appeals have been thrown out on technical reasons. Now, of course, Washington Post, to be a little bit more sensational about it, has gone after, Attorney Smith, Attorney Jones, Attorney Green, and pointed out, this attorney has 12 that this has happened to, this attorney has 14 this has happened to, and this attorney has 20 that this has happened to. But it's also pointed out over and over again that the reason this is happening is because the draconian use of technicalities or form over substance in the Virginia Courts of Appeal, in which something being filed a day late or without the exact proper certification or any number of small technical errors that really don't affect anything to do with the argument and won't affect anybody's ability to read and understand the argument are used to throw out appeals. And the Washington Post was just hammering Virginia about this. And the appellate courts, at least their original reaction to this was, well, every time now that a case is thrown out on technicality, which, well, the courts seem to continue to be looking for all these technicalities to throw things out. They didn't seem to have stopped that, but every time that one was thrown out on a technicality, they then started reporting people to the bar. Well, in steps the General Assembly of Virginia, and our very conservative legislature, the General Assembly, actually stepped up and said, no, now this is ridiculous. Here's the way it's going to be. If something's thrown out on a technicality, the courts, and the lawyer raises the issue or files for a delayed appeal, the courts shall grant a delayed appeal. Shall. It didn't give the courts any options in this. So it did, however, give the prosecutor or the Attorney General a veto, but it didn't give the courts any option. The courts shall allow a delayed appeal. And this, in a system where consistently and constantly we see our courts saying that they must use legislative intent as the primary tool for interpreting how things should be done. And you see this all the time as a criminal defense attorney. They always go back to legislative intent in statutes and where there's absolutely no record of what the legislative intent was ever. It seems to get created out of whole cloth and almost always seems to be the legislature intends for your client to go to jail, counselor. However, in this point, where the legislature has clearly passed a law in reaction to the use of form over substance, it'll be interesting to see where the appellate courts go on this. And I'll say that I think that this is something that I think the appellate courts are reacting to. I'll say this because one of my clients had, at my urging, filed a habeas for some minor error and in filing. And before the law even went into place, the Supreme Court granted a delayed appeal rather than a habeas, which is the way they would have handled it before, which shows that they're considering things differently. And I recently filed, not through my own fault, there was a case where the transcripts were not filed timely, despite my even getting an extension in time for filing. They were filed untimely. The filed for a delayed appeal in that case, and I just over the weekend, actually yesterday, got back a letter from the Court of Appeals. Now, mind you, it took them 2 months to get me a letter back, but I got back a letter from the Court of Appeals saying that they had received it all. However, I had not certified that my client, who is now serving a 20-plus year prison sentence, actually wanted an appeal. So I just have to write them something certifying that my client wanted an appeal within the next 30 days. And I believe that in olden days that this would have just been a rejection straight up because it wasn't certified properly. So I think the courts are coming around somewhat on this. But as you'll see in the opinions I'm going to discuss today, they haven't come around on this rule, specifically 525 and 5A18. First case we're going to discuss is Townsend against the Commonwealth, 042223, record number, 16th September 2005. Now, this is the case where the Supreme Court simply refuses to hear an argument or refuses to discuss an argument. It says that, well, basically it refuses to hear the argument because the argument was slightly different in the trial court than it was on appeal. So here's what the situation is. During a trial, or during voir dire, jury selection, for those of you who haven't been forced to learn strange foreign terms for easily substituted English words, during jury selection, defense counsel tries to strike two people for cause. The first person he tries to strike for cause is someone who knows members of the victim's family. The second person he tries to strike for cause is a lady who's married to one of the deputies that works in the courthouse, and apparently, at least at some short period of time, was in the courtroom during voir dire. The reason he tries to strike him for cause is bias. He claims that they're going to be biased during the trial. Well, the judge does a Mrs. McGillicuddy on him and just says, no, they're going to stay in the jury pool. Okay, obviously, defense counsel preserves this all the proper ways that they're going to be biased, they're going to be biased. However, once it hits the appellate courts, the actual argument made in appellate courts is that they both should have been struck because their presence on the jury undermined the public's confidence in the integrity of the judicial process. Now, why would it undermine the public's trust in the judicial process? Well, because prejudiced jurors, biased jurors, don't lead to fair trials, right? Pretty obvious. However, from point A to point B, there's a gap, a little bit of a gap. And I'll tell you what, now I don't know the person who tried this, and I don't know, the case law on this exactly. But off the cuff, here's what I feel like happened. And we've all been there. Defense counsel knew there was a reason to object, and he raised the reason to object that made sense. Bias. Well, once he went to write the appeal, the way it was framed for an appeal is slightly different than the way he stated it during court. He didn't state it exactly correctly. Well, how could he not state it exactly correctly? Well, when you're there in court, you don't have all the case law at your fingertips. You don't have the statutes right there. You're standing there in front of the jury doing this. You're not sitting in the law library with all the books available. I have seen some attorneys go in and have somebody sitting behind them doing research the entire time and waving them over and whispering in their ears so that they get everything exactly right. But most attorneys just don't have the resources to do that. So you preserve the error as best you can preserve the error. And then when you get to the point you're writing the appeal, you look and you go, okay, well, it was framed a little bit differently than what I said, so I'll argue it the way that the courts expect it to be argued. And it's clear. Why would public confidence why would public lose confidence in a jury because having biased jurors is not a confidence-building endeavor. So, however, because it wasn't phrased exactly correctly, and the exact correct argument wasn't made, the Court of Appeals under 525, or actually the Supreme Court under 525, dismisses the argument, says it wasn't preserved, therefore we won't listen to it. And I'll go through a little bit here. Let me see. Application of Rule 525 is particularly appropriate when the basis offered for reversal of the trial court is not that a juror was actually biased, and thus not indifferent to the cause, but that a public policy consideration should override an otherwise legitimate jury verdict. It is fundamentally unfair to overturn the valid decision of a jury for reasons never given to the trial court and which do not go to the merits of the case or the actual bias of a juror. And it sets out the actual rule here would be public confidence in the integrity of the judicial system as a ground for excluding juror for cause must be raised in the trial court or that issue is waived. Okay. In this particular case, which I think is perhaps fairly close, this may be an appropriate decision. He actually didn't raise the exact argument he made in the Court of Appeals. He said in the trial court that they're biased. He basically changed that in his appellate arguments to the appearance of bias will undermine the legitimacy of the courts. So he's not actually arguing in the appellate courts that they are biased. He's arguing about the appearance of bias. Is it a little bit of hair splitting? Yeah, it's a little bit of hair splitting, but it is what it is. This kind of reasoning, however, while it may be correct here, is something that's really disturbing. It is to say that because you've got because you have a jury verdict, public policy concerns, say for the instance, the Fourth Amendment concerns that the police should not be able to just go into your house and search it without you knowing or being there or having a search warrant. Fifth Amendment concerns that police can't force or coerce a confession out of you. These sorts of things cannot overcome a jury verdict. Kind of disturbing. And here's the most disturbing part of all about the analysis that's here. The consistent application of Rule 525 advances the rule's purpose of avoiding unnecessary reversals and retrials. Okay, that is a very disturbing statement. Because what that says, what is inherent in that statement, is an understanding that without the application of Rule 525, there would be reversals and there would be retrials. That is to say that 525's purpose is to void legitimate errors based upon legitimate claims based upon legitimate errors which would lead to reversals and retrials. And ladies and gentlemen, with that, I'll get off my soapbox and move on to the next case. The second case we're going to discuss is Hicks against the Commonwealth of Virginia. Record number 042717, again from the 16th of September 2005. Now, the main issue in this case is whether or not you can be found guilty of attempting to have sex with a minor when there was no minor involved. And here's the basic background. Hicks is IMing with someone whom he believes to be a 13-year-old girl. He arranges to meet with this 13-year-old girl, goes to the meeting spot, and it turns out that he was being scammed by police officers. Now, mind you, at least from the facts that they're put out in the case, Hicks is not an innocent bystander here. He apparently was instigating a good portion, if not all, of the contact. However, when they get to trial, Hicks's counsel raises impossibility as a defense. Says that, look, there was no 13-year-old girl, period. All there was the police officer. The Supreme Court rejects that argument, saying that, well, there's a difference between legal impossibility and factual impossibility. Legal impossibility is when you do everything you intended to do, you still wouldn't have broken the law. Factual impossibility is if you did everything you intended to do, then you would have broken the law. However, some sort of act or intervention occurred which kept you from doing everything you intended to do. The distinction is important because legal impossibility is something which you can't be convicted if something's legally impossible. Factual impossibility, you can be convicted. So they look at this case and they say, okay, Hicks was stopped from getting with a 13-year-old girl because the police were there and intervened. Apparently Hicks' counsel tries to argue some sort of hybrid thing where, and it might have been something along the lines of this. Now, this is kind of my own spin on it. It's not that anyone actually intervened because there was no Party A, Party B, and Party C intervening. What there was Party A and Party C. Party B, which would have been the 13-year-old girl, never existed. And therefore, it's semi-factual and semi-legal impossibility. And the court rejects that and says, no, this is straight-up factual impossibility, and therefore you can be prosecuted for attempt when there's no factual, when it's a factual impossibility. Lays out a kind of vague, here's what attempts are. An attempt to commit a crime is composed of two elements: the intent to commit and a direct, ineffectual act done towards its commission. And it lays out more specifically what an attempt is in this sort of case. By definition, the crime of attempted indecent liberties requires only that Hicks make certain proposals or invitations to the victim. So when he was IMing her, he was already making the attempt. The simple act of proposing or inviting constitutes the completed crime if the offender is over the age of 18 and the act is done with lascivious intent and the victim is under the age of 14. As I read the facts in this case, the Supreme Court strikes me as being pretty much dead on here. I realize that there's some play here in the fact that they're really not an intervention. There was actually the police at all times. So there was no intervening factor which made a factual impossibility. It was an always existent factor which made a factual impossibility. But still, I think that the fact that Hicks seems to have been the instigator of the communications over the IM is something that I believe probably makes the Supreme Court correct here. And then, of course, we get to the 525 section. And the 525 section, once they got to appeal to the appellate level, the counsel raised an issue saying that, look, he was indicted under Section A of the statute and convicted under Section B of the statute. Therefore, it's an invalid conviction. And the Court of Appeals refuses to hear this, saying that, well, it lays out how counsel looked at it and said the indictment actually quotes or states just the statute, but the language it quotes is from Section A of the statute. And what they convicted him of would have to be under Section B. And to be honest with you, I think that this is something that's what this rule is set in place for. Because if you raise this argument during trial, if you argue that he wasn't convicted of what the indictment was, well, at any time during trial, the prosecutor can amend the indictment and could have amended the indictment in this case. And if such an amendment was so staggering and earth-shattering that the defense counsel wasn't prepared for it, then there can be a continuance or a mistrial or something along those lines to give defense counsel time to get prepared for that section of the argument. So I think here, this is probably one of the things where 525, the use of 525 is directly on point. And ladies and gentlemen, with that, we move to the most interesting case of today, and I'll be with you on that one in just a second. And the last case for today I'm going to go over is Paradise Carnell Jackson II against Gerald K. Washington, Warden, Buckingham Correctional Center. Record number 042130, again decided on the 16th of September 2005. Now you'll notice the styling is slightly different, and the reason, for those of you who are still learning these things, the reason the styling is different is because technically it's an action against the warden, because the warden is holding the person illegally or unconstitutionally. The issue is whether the circuit court erred in denying Jackson's claim in the petition that his trial counsel rendered ineffective assistance of counsel by failing to object to Jackson being tried before a jury while wearing a jail-issued jumpsuit. Now here are the facts, basically, and the procedure in this case. Jackson is in jail awaiting trial. The jail loses his civilian clothes. He wants to go to trial in civvies, not in his jumpsuit. Generally a good idea. He tells his counsel, well, he tries to get stuff from jail. They tell him, we'll get back to you when you get transferred to another jail. We'll find it by then. He tells his counsel he wants to be tried in civilian clothes. Counsel tries to call his mom. Apparently, it says in here several times, but is unable to. So when it comes trial date, in comes Mr. Jackson. He's in his jail suit, and the trial goes forward. His counsel does not object to the fact that he's being tried in his jury suit, and he even testifies while wearing the jail suit, testifies in his own behalf. He's convicted. While waiting for sentencing hearing, he files a pro se motion to the judge saying that he has had ineffective assistance of counsel because he was wearing a jury suit, the jail suit, when he went to the jury trial. Upon appeal, I don't know if the same counsel or different counsel, the issue is raised that he was prejudiced by being tried while wearing a jail suit in front of the jury. Of course, the Court of Appeals refuses to hear this under 5A18, saying that counsel didn't object during trial, therefore we ain't going to listen to it. And the Supreme Court refused to hear any argument, period, if I remember right. So then we get to the habeas. District Court hears the habeas argument and says no, not going to happen. Supreme Court of Virginia then gets the habeas argument. And in this argument, they go to Strickland. And under Strickland, there are two rules. First is, was counsel ineffective under an objective standard of reasonableness? Second, was that ineffectiveness so bad that it adversely affected the defendant during trial? The Supreme Court finds that not objecting to the fact that he was in a jury suit is ineffective assistance of counsel. It then also finds that because the jury suit carries with it, the jail suit, carries with it all sorts of implications that, well, on top of which it also finds that because the jail suit is indicative only really of the fact that you couldn't afford bond, then it is a due process or equal protection argument. And it says that that's it. It's ineffective assistance of counsel, adversely affects how his trial comes out, and they order it back for habeas relief. It's an interesting trial. And I got a few comments here. Okay, now I'm going to go back and discuss a couple of the things which I said I would go back and hit. The first thing is going back to where the Supreme Court, the justice who wrote this, talks about how there have not been any cases of this type previously, and therefore he says how wonderful a job the bar and the bench must be doing in making sure that all these indigent clients appear in court in civilian clothes. My comments, actually I have it on the side here, I doubt you can read it from that distance, but basically says, "Oh my God, has the justice ever been in a courtroom?" Which is terribly unfair. It was my first reaction. It was terribly unfair. And I tried to check to see if the justice who wrote this had actually had trial experience. For all I know, this is a 25-year veteran of trials, criminal trials. Couldn't find anything really. I found that he teaches a class in Roanoke, but it was an appellate level class about how the Supreme Court works. Nothing about anything criminal or anything along those lines. I'm here to tell you, having done quite a bit of indigent defense and knowing quite a few people who do quite a bit of indigent defense, that at all the time there are people going into trial in jumpsuits. It happens every day of the week. Now, most of those trials are in front of judges, of course. They're still going into trial in jumpsuits. And, I don't know, let me think, maybe half of my jury trials have been with the gentlemen in jumpsuits. And that's not unusual. If you walk into a jury trial and it's an indigent defendant, you will quite often see somebody in a jumpsuit. A lot of times these guys don't have anybody. The homeless guy off the street, he doesn't have anybody to call and get clothes. The people who've been abandoned by their family, who have moms and dads and brothers and sisters who will not return your phone calls or his phone calls, they just don't have the clothes available. And a lot of times the stuff they're arrested in is worse than what they're wearing. The jumpsuit. The guy who's arrested at 3 a.m. in his skivvies. The lady was out clubbing and has the shiny purple top with the skin-tight green pants. The homeless guy who's got 4 shirts he was wearing to keep warm under a jacket he pulled out of a garbage can 2 years ago, and some torn up jeans which are about 4 sizes too large, held in place by a rope. None of which, mind you, has been washed in the last 3 years. And these are guys that, even if they wear the civilian clothes they came into jail with, it's going to put them in a worse position than they were otherwise. The question here becomes, who's going to be on the hook for getting them civilian clothes? Obviously, I am a little bit worried about this because it talks about the nominal effort made by defense counsel to get clothes. Well, there's not much more. I'm not a tailor, and most of the people I know aren't tailors.
I don't have a closet full of extra clothes that I can hand out to somebody who's going to trial. Now, it's possible, in particular trials, one might buy some clothes for one's client. However, if you do a lot of criminal defense, a lot of indigent criminal defense, it's not a viable solution. You cannot afford to buy every other guy clothes. If you are getting paid $428 to do a jury trial for a guy, you cannot afford to spend $100 of that getting him clothes. Now, mind you, if you've got 20 other cases, all of which are going really simple, and you get paid easily on all those, you might be able to do it once or twice. If you've got 20 cases, half of which are going to jury trials, which I realize is unrealistic in Virginia, but if you've got a number of cases going to jury trials, you just cannot afford to do that. You're not getting paid enough as an indigent defender to do that. And oh my God, if you're a public defender, there's no way. There is absolutely no way a public defender can afford to do it. But I'll admit, I have a clip-on tie that I give to clients to wear into court. But that's as far as I've gone. It's just not realistic. And I tell you all, if you go into a busy courtroom and wait to watch a jury trial, the odds are, if it's an indigent defendant, you're going to see somebody who's in a jumpsuit. It's the way it is. Now, the fact that this hasn't been raised previously in court, in the appellate courts, is pretty amazing, actually. And I think that now that this case has come out, I think we're probably going to see it a lot more often. Or at least what we're going to see it happen a lot more often is somebody objections prior to trial about the fact that your client doesn't have clothes to wear for a jury. At which point there'll be arguments about who's going to pay for it. And we're going to see how that turns out, because trying to pry money out of the hands of judges for experts or anything is almost impossible. If I have to pry money out of their hands to buy clothes for my clients, I'll be interested to see what becomes of that. Specifically, I have people that I defend who are actually in prison already. And I have people who I defend who are in juvenile detention facilities. People who don't have civilian clothes. Nothing there at the facility for them to wear, particularly a juvenile detention facility. If they've been there a couple of years, even if they had clothes when they came in, they don't have it anymore. It won't fit anymore. So it's going to be interesting to see how civilian clothes become available for these people, because it's clear that they don't have civilian clothes, and I don't object to it. It's ineffective assistance of counsel. So it's another thing I get to object to every time I go to trial. I think this is interesting. I am disturbed by what I think the court is implying, that I have to go out and buy clothes for my clients. But I think this is one of those things that we're going to see become a fairly normal argument. It's one of those things that when the jailhouse lawyers get a hold of it, we're all going to start seeing habeas about this one. So we're all going to start making the argument, and we'll see where it ends up. Well, ladies and gentlemen, that's it for today. I think I've talked enough, and a few times I've even talked in circles, so I hope it all makes sense. I hope some of it was interesting. I hope some of it was useful. Now, here comes the CYA stuff. Ain't none of this legal advice. Again, I say to you, ain't none of this legal advice. If you are interested in using anything I've said here, I strongly urge you to go do some research. I haven't read a single one of the cases that the Court of Appeals or Supreme Court relied on. I haven't done any research on anything other than reading the opinions. I may be stating laws that I remember from a case 2 years ago that are no longer the law, that have been changed by statute or changed by the Court of Appeals, but I haven't had reason to research them since then. So that's it. That's the CYA section. Next week, I'm not sure what I'll talk about. Maybe I'll talk about the Court of Appeals opinions for the coming week or Supreme Court's opinions. I don't know. We'll have to see if they come out with some. Anyway, I'm sure I'll find something to talk about. And with that, ladies and gentlemen, it's a wrap. Y'all have a good week.